Okay. Why aren't you working now? There we go. Sorry, I was having technical difficulties. All right. So we're on to video number 3, chapter 5, and we're talking about interception orders. So let me just review real quickly. We're comparing interception orders with search warrants. Interception order has to be signed by the DA, has to be signed by the lead law enforcement officer. It's going to be only those who are certified by the state can then be allowed into the room. Once the order is signed, then that room where they do the interception order is restricted. And part of the declaration in your interception order says that you have a dedicated location, that it's secure, and meets the standards for an interception order. Then in 30 days, the interception order is only good for 30 days. And then at the end of 30 days, the court's going to receive the 10-day report and then make an evaluation of whether or not the interception order will continue. Sometimes law enforcement will come in and say, hey, we're done. Other times they'll come in and say, Judge, we would like another 30 days. So it's up to the court. And the court looks at the amount of information relevant to the investigation that the officers are receiving. And the court is receiving reports every 10 days, so the law enforcement's in constant communication with the court. And then privileged information is going to be logged, identified, logged, presented to the court, so the court knows all privileged communication. The court's going to be able to listen to the communication if they want to. Law enforcement is going to maintain that privileged communication in a separate file, so that other people do not have access to it. Okay. Intercepted information is returned to the court. The order will include an order directing companies and employees to assist law enforcement. So that order is going to include a request for PG&E, for instance, phone companies to assist law enforcement. Because oftentimes when law enforcement is doing a wiretap, phone numbers coming in, they'll be able to identify just the physical number coming in to the person of interest, but they're not going to know who owns the phone number, where it's who owns it, where it's located. So they're going to have to go to the phone company to get certain information. And again, it could be by way of a search warrant or by way of court order, depending on what information they're asking for. All right, the orders include what type of communications are within the parameters of the order. So, for instance, if this is a individual that's married, communications with the spouse is going to be privileged. It's not as always so. There's not always this real bright red line between privileged communications. For instance, if it's a spouse and law enforcement suspects that the spouse is also involved in the criminal activity, they're looking for code words, they're looking for slang language, they're looking for things to determine whether or not the spouse is involved. If they can determine that the spouse is involved and they can show the court that the spouse is involved, then the court's going to allow them to record the communications between spouses. If not, then the court may consider some of those discussions privileged. One of the things law enforcement is going to do is they're going to document, okay, this is a conversation between spouses, and then let the court decide whether or not it's privileged or not privileged. So the court will dictate how long law enforcement may listen to the communications before deciding whether communication applies to the interception order. So the court has full discretion to say you can listen to the first 5 minutes, you can listen for the first 2 minutes. At any point that the officers themselves determine that this communication is not relevant to the investigation, they have to stop the interception. They have to turn off their recording device. If they believe that the individual may be speaking in code terms, they can continue to listen. They may have to support their suspicions to the court and show the court that this is why they continue to listen to this particular conversation, because of certain terminology that's being used, etc. And then the court can decide whether they're allowed to keep that information or they'll have to file it separately and not be able to use the information later on in court. All right. The other unique thing about an interception order does not apply to search warrants is an interception order only applies to certain types of crimes. So you're not going to get, if you have somebody that the law enforcement believes is doing burglaries, you're not going to be able to get a wiretap. It has to be espionage, murder, kidnapping, robbery, extortion, counterfeiting, drug sales. So there's a very specific list of crimes that apply to an interception order. And this is very different from a search warrant. A search warrant does not have this restricted list. So that's another distinction between search warrants and um, interception orders. So I did just a minor comparison. This is not everything, but I wanted to show you the distinctions between interception orders and search warrants. So both of them require a magistrate's signature. Interception orders are limited to certain crimes. Certain search warrants are not. There's time limited in time, so an interception order can only be executed for up to 30 days. Search warrants, the execution itself has to be within 10 days. Usually a search warrant is not going to take more than a day in most circumstances. It can take longer. So there's a distinction there, a minor distinction there. Interception orders limit who can participate. Search warrants, not so much. A search warrant you can have, for instance, if they do a search warrant on a home that they believe is involved with drug sales, and they know that a family lives there with children, they're going to bring in law enforcement. They're going to bring in the welfare department. They may bring in medical personnel. If those children have been exposed to chemicals, they're going to want to test the children. They're going to want to test the children's clothing. And then social worker is going to get involved because they may determine that the children will be separated from their parents. So very different between it's a distinction between search warrants and interception orders. And then interception order is going to be limited to certain subject matter, what they can listen to, and search warrant there's no limitation other than what's listed in the search warrant for searching for things. Now I want to go back just to one of the other slides that I covered in video number 2, and that's this one, modern technology. For some reason I thought there was another slide, but there's not. So I want to clarify for mechanical devices. A tape recorder is not considered a mechanical device that requires a search warrant. Thermal imaging devices, however, hearing devices are required. Generally, you're going to be required to get a search warrant. So a thermal imaging device provides you information. You can be outside a home, and the thermal imaging device can provide you with information about what activities are going on in the home. You may not be able to identify a male from a female, but clearly with the quality of thermal imaging devices today, you can see people walking around. You can draw a significant amount of information. And again, it's information that's not available just using your natural senses. So anytime you want to use a thermal imaging device, you're going to require a warrant. Hearing devices are a little different. If you can hear with the unaided ear, then it's not considered to be an intrusion. So if I'm standing next to somebody and they're having a conversation and it happens to be information that I'm going to use against them later on, that's not an intrusion of the Fourth Amendment. If you talk too loud, if you share information with somebody that's going to share it with somebody else, you're not protected under the Constitution. If I use additional equipment, hearing sensitive devices, then for instance, if I can take a device and place it next to a and hear what's happening in the next room, and that information is not available to me if I just listen with my unaided, with just my ears, then you're going to need a search warrant. X-ray machines, search warrant. Tracking devices, the law has just recently changed. One of the briefs you're going to review is actually the case that changed the law, because tracking devices or GPS devices provide so much information now that they now require a search warrant. So that standard that the court uses whether or not the, law enforcement can look in your phone, whether or not they can use a GPS device. It's the same evaluation. Are you receiving, or is law enforcement receiving so much information that the scales lean towards more individual rights than towards the officers need to investigate and to maintain law and order? And with tracking devices or GPS devices, there's so much information you can receive now. You can also use satellite imaging. You can use satellites so you actually can, get real-time photographs or real-time video of what's happening. And that's just way too much information. And so the courts have said that if you are going to use a GPS device, even if you could do surveillance, let's assume that the person's driving on public roads, you're still required to get a search warrant. Dogs, drug sniffing dogs, we talked about when you approach them at the front door within the curtilage, but generally drug sniffing dogs are allowed. If an officer does a traffic stop and they use a dog to walk around your car, as long as that time that they're using is reasonable to issuing the traffic ticket, you can use a dog outside the vehicle. It's not intrusive because the dog, what information the dog is receiving is coming from outside the vehicle. Right? They can only smell, for instance, cocaine or marijuana from the chemicals coming out in the atmosphere of the vehicle. So that would not require a search warrant. So I just wanted to go over that with you in a little more detail. So this concludes video number 3 on chapter 5. This are all the slides for chapter 5. So again, you will be required to produce and submit in writing an outline based on the slides that are being shown on this particular tape, and go to assignments for specific information if you need more information. So that's where you'll go to assignments, and you'll be able to determine from there, what you need to do to complete chapter 5. And then I will provide you in the near future with information on how to submit your briefs, and they'll be due the following week, but you will get an email from me before then, or a notice of what briefs are due. Specifically, I will list the briefs for you, and I will give you your timeline to have your briefs completed, and you will upload them and submit them through Canvas. So let me find my cursor. There we go. Have a great day. Remain safe. Any questions, be sure to